why the validity conditions under Section 11 puts a restriction on not allowing any adoption when there is already a son living at the time of adoption. So the time of adoption becomes very important when you are talking about, say, even if a male Hindu, supposing he is divorced and then he adopts, for example, and then, or say, sorry, not a male Hindu, but a female Hindu. A female Hindu, supposing she is a divorcee and she adopts a child, which is allowed under the Act because she has the capacity under Section 8. Now she adopts this child, and let's say that the child is adopted, but she remarries. So the date of adoption becomes very important in order for the adoption to be validated, to say that it is valid under the Act. Because after all, when you are a divorcee, we have seen that if you are a unmarried female, or if you are a widow, if you are a divorcee, in all of these cases you are allowed to adopt, and if you are a widow also. So when you have adopted, however, the next step is in Section 13, what you see is the status of the parents of the adopted child. Because I believe I mentioned that if the marriage is prior to the 1955 Act, where the Hindu male has been allowed to practice polygamy, and then supposing he has married more than one wife, then those marriages are considered as valid even after the enactment of the Hindu Marriage Act of 1955. We know that after 1955 only, the marriage of more than one spouse, where you're marrying a spouse during the subsistence of your first marriage, we know that that kind of a marriage is not allowed only after the commencement of the Act. Now, if there is an adoption that takes place and then the marriage had happened prior to 1955, now the question is, who becomes the adoptive mother for the purpose of that adoption of that child? So in Section 13, that is what we see. And in Section 13, what we find is, if there are more than one wife, then the eldest mother becomes the stepmother. And as for the younger wife, that means the wife who was taken second or third, whoever they may be, they don't have the status of being called adoptive mother, but they will become stepmother. Now, the stepmother and the adoptive mother have a very different claim towards the child, because the adoptive mother, for the purposes of this adopted child, with respect to property, etc., she is the one who becomes responsible to the child. So that is how this Section 13 identifies certain differences that will lie if you have, say, another example, if you have a unmarried daughter, because it is allowed now under the Act to adopt a child. So she adopts, and then since she's unmarried, now after adoption she decides to get married, which is also allowed. Now the adopted child, however, she will now have to be considered. The mother will be the adopted mother only, and this child will have only one line of relations. That means the line of the adopted line, wherein the female who has adopted, like the grandparents, will be the mother and father of this unmarried daughter who has adopted the child. So for all purposes, the adoptee, that is the child who has been adopted, will be taken care of by the adoptive mother. And if she marries later on and then she has a husband, then the husband is not called the adoptive father, the husband becomes the stepfather. Now, in the Act, what we have been discussing about is the most important area that has been highlighted, and which has brought us to a point where we are looking at what about this adoption of more than more than one of the same gender. That is the main issue that has been coming to the court, and there was a judgment of the Supreme Court. So today, what we want to basically look at are the cases that we have under the Act, because this case that we want to discuss right now is adoption of Payal at Shavin Vinay Pathak and his wife Anita Sahe. Now, this is not a Supreme Court judgment, but this is a Bombay High Court judgment. And I think when we are interpreting all of the provisions of the statute, one thing that we cannot say and we cannot rule out is that the judge or the person who is giving that judgment generally has that power to interpret that provision, and it depends a lot on not only the presentation of the lawyer, but it also depends on how much of the law that we can interpret with the needs of the society today. So there have been certain judgments which are considered anomalous for the purpose of the Act also by certain high courts, because how do you see the provision of the Act is what ultimately matters. Example is, if we are talking about, say, the capacity of the married wife also, if we say that, if in our facts we come to know that there was a proper ceremony conducted of a giving and taking of the child, for example, and there was nothing to show that that the ceremony was not fulfilled, even the mother was present at the time of adoption, but the validity of that adoption hangs on what? If a father adopts under Section 7 of the Act, we know that the most important thing that he has to do is he needs to take the consent of the wife. Now, how do we determine the consent of the wife is one thing. If we look at the provision, it says consent of the wife is required. We have already said that formal registration of an adoption deed is not compulsory, but there is a presumption by the court that if there is a registration of the adoption deed, there is a presumption by the court that the procedures of adoption have been validly followed. But it does not give you a foolproof evidence. It is just a corroborative evidence that the courts have held. So in this manner also, when we are referring to this kind of consent, how do we determine this consent? Because in some cases what you find is the mother is also present, and she was also present at the time that the ceremony was being validly conducted, but does her presence amount to giving consent for the adoption of the child? That is the question that we are concerned with. Now, this will depend on your circumstances, of your facts, of whatever evidences are brought to the court. And in fact, in one of the cases, a 51-year adoption was invalidated by the court on grounds of no consent being given by the wife at the time of adoption. Because remember, we said that effects of valid adoption amounts to a lot of issues when we are referring to property. And it is all about what happens, because under the old Hindu law, you did not have a child who could, if you adopted a child, it basically was interpreted as a child who will now have a share in the property. And even if the child has been adopted way after the death of the deceased husband, since the widow had no right to adopt under the old Hindu law, that child was deemed to be related to the deceased husband. And the child automatically, once the adoption took place, it was deemed that this child, who is a son, has now been born into that family, having a share in the property of this joint family. So there was this issue of negotiating with the property, and several property disputes used to arise. But like I said, this doctrine of relation back has been abrogated by the court. But till date, there are some instances of decisions of the court wherein we see that there has been an interpretation of this doctrine of relation back to the extent that the courts are still hanging on to that old law of the son being adopted, having a relationship with the deceased father. But now, under the Hindu Succession Act of 1956, in Section 14, the widow has an absolute right to any property that she might have acquired at the time of a partition in lieu of her maintenance. possession or the owner of that property after the enactment of the 1956 Hindu Succession Act. So since this is the case now, that regarding the requirement of only the son being able to have a place in that property is no longer recognized under this present modern law, but now it is considered that the child that whom the widow adopts is she is adopting that child in her own right as well, and whatever properties that the widow may have, he becomes entitled to inherit that property once there is a decease, or even the widow can make a will of that share of the property as well. So one thing that we want to look at today is this area of that multiple adoption of the same gender, which was a concern because we have seen in clause 1 and clause 2 of section 11 that there are restrictions, and if there is the presence of those male generation, then at the time of the adoption, then no son to be adopted, or if there is a daughter or son's daughter are living at the time of the adoption, then we said that no daughter can be adopted. Now, in one of the cases that we will see in our case material is this case of 2010 that was given by the Bombay High Court, and the Bombay High Court has discussed it, where it is talking about the adoption of a child under the Juvenile Justice Act. Now, the right to adopt basically under the Constitution also, there are several areas of the Constitution that has been discussed, and we are looking at basically same gender multiple adoption, and this is with respect to the Juvenile Justice Act. So this judgment of the Bombay High Court is extremely significant. It is there in your case material only, adoption of Payal at Sharin Vinay Pathak and his wife Sonika Pathak, 2010 Bombay High Court judgment. Now the issue that was involved in this case was the interpretation of the provisions of the Hindu Adoptions and Maintenance Act, and this has of 2000, which was amended in 2006 in the context of the adoption of abandoned children. The Juvenile Justice Act was enacted to provide rehabilitation of who we call our orphaned, abandoned and surrendered children, and adoption is one of the ways that has been recognized by the Parliament to facilitate this object of rehabilitation as given under the Juvenile Justice Act. Now, in this case, that is this adoption of Payal's case, the petitioners already had a daughter, and if you will look at para number 3 and 4, that is where your facts are mentioned, and we have been given the dates of the birth dates of the adopted parents, only to consider regarding the age gap. Remember, the age gap has to be 21 years. If the male is adopting a female child, 21. If the female is adopting a male child, then similarly again 21 years. So they have given us their date of birth also, and apparently they have already got a daughter, and who was born in the year 2003. Now, they had obtained guardianship rights with respect to a surrendered female baby. Now, this female baby, in paragraph 4, it seems that there was a petition that was filed in the court, and the petitioners had sought their appointment as guardians for this female child. Now, the female child for whom they have sought guardianship was born on 12th November of 2004, and the mother's identity has not been revealed also in the interest of the privacy. That's why who she was has not been disclosed when the case was also brought to the knowledge of the court. And the mother, that is the mother of this child, who is going to be adopted by this adopted family, they executed, she had a husband also, so both the mother and the husband, they had executed a declaration 4 days after their child was born, that is on the 16th of November of 2004, and they had recorded their circumstances in which they had decided to surrender surrender the child at the nursing home where the child was born. Now, in the declaration also, the mother and the spouse, both of them had stated that they had been counseled also prior to giving up of the child by a placement agency, and they had voluntarily agreed to surrender their child. Now, at the foot of the declaration also, the Indian Council for Social Welfare had made an endorsement of having counseled the parents, and everything was written regarding the awareness of the mother of giving up this child. And one of the grounds under the juvenile justice under this is that if you are going to give your child in adoption, then you have a time to consider for 2 months, and within that 2 months, you can reclaim the child if you decide to change your mind on giving up that child for adoption. So the parents, however, after 2 months have lapsed, also they have not claimed the child, and in fact, from the facts of the case, we find that the child remained with this uh, Vinay Pathak and his wife from the time that they have approached the court. The child has been with them for the last 4 years, and in fact, both their daughter, because their daughter was born in 2003, now this adopted child is born in 2004, so they were around of the same age, only a few months gap, and they were actually attending nursery school together. So the child had been with them, and so the petitioners now have filed an application to legally adopt the child. Now, in this case, you will find that there has been several references of the Hindu Adoptions Act, provisions of the Juvenile Justice Act. More importantly, we want to look at the provision of the Juvenile Justice Act, wherein the legislature has made it possible for the adoption of children who have been orphaned, who have been abandoned, without recourse to the personal laws. Because one of the grounds why this became necessary also was under the Christian personal law, for example, you do not have adoption laws. So there are personal laws that deal with this aspect separately. The Hindu law of adoption has made it very clear that these are the certain requirements for a valid adoption. So now the question is, if the Hindu Adoption Maintenance Act, restricts the same gender adoption, but if under a separate enactment that adoption is allowed, then can these Hindu couples still take a child under that particular act and legally adopt the child for the purpose of making that child their own? Now that is the basic question that we need to determine. So in this case, there were contexts with respect to Article 21 also that was discussed, and it was in fact observed in this case that adoption is a facet of the right to life under Article 21 of the Constitution as well. And they had also tried to say that where there is no provision for a personal law adoption, then the court has accepted that they can make adoptions under these other enactments as well. And the right to life includes things basically which make life meaningful. So in this case, the court held that one thing is that the right to life, on the one hand, right of parents and individuals who seek to adopt to give meaning to their lives, and equally significant in the context of the Juvenile Justice Act, the right to life that is specially protected is the right of children who are in need of what we call is a special care and protection. Now, as far as the restriction that is imposed on the adoption of the same sex of the child by the Hindu Adoptions and Maintenance Act of 1956, the court in this Bombay High Court judgment had held that this might give way to, say, the statutory provisions in the Juvenile Justice Act. Now, the question is, where there are two pieces of legislation where the same subject might have been discussed or might have been raised, then what is the way out in such scenario? scenarios, and the court spoke about what they call is a harmonious construction of two pieces of legislation. So there is a possibility that if the two pieces of of legislation, if there is no conflict of the interpretation, and even if supposing there is a conflict also, it has always been decided that whenever there is a conflict between two laws, it is the later law that will prevail, that is the later act that will prevail. And we know that Hindu Adoptions Maintenance Act came in 1956, and this is Juvenile Justice Act was enacted in 2000. So now why this later act will prevail is a well settled principle, already held by the courts, that where there are two special acts which deal with the same subject matter, the legislation which is enacted subsequently will prevail. And the court clarified the general prohibition of the same gender adoption that is there, and the later act basically creates what we call is an exception in the case only of abandoned children. So the parents now here is that they are trying to adopt the child who apparently is an abandoned child, and then whenever we look at an abandoned child under what we see is your Juvenile Justice Act, rehabilitation is taken care of by the welfare board under this particular act, because there's a board that has been created. So in your Juvenile Justice Act, there are several provisions. One provision that talks about offering children in adoption is in section 41, which comes under chapter 4 of the Juvenile Justice Act. And in section 41, if you look at subsection 6 of that act, it states that a child may be allowed to give in adoption, first condition being to a person irrespective of marital status. Second condition, to parents to adopt a child of the same sex, irrespective of the number of living biological sons or daughter. And the third condition is to childless couples. So you have three conditions under section 41, subsection 6 of the Juvenile Justice Act, which talks about the possibility of uh, adopting same-sex children irrespective of how many living sons or daughters you already have, because you are allowed to do that under this particular act only. So it's basically what has been created under the Juvenile Justice Act is an exception that is there under the Hindu Adoptions Maintenance Act. So the purpose being, this is a social welfare legislation and beneficent for those children who are abandoned, who have been orphaned, who have no identity of their own. So that is the reason why such adoption procedures have been separately mentioned in the Act itself, talking about the requirement that you will allow adoption under this Juvenile Justice Act, irrespective of there being a clause under Section 11 of the Hindu Adoptions Maintenance Act, talking about the fact that you cannot have adopt a child of the same sex. And in clause double A of the same subsection, section 41, there is a definition of adoption also which has been given, and it says that it is a process through which the adopted child is permanently separated from his biological parents and becomes the legitimate child of his adoptive parents with all rights, privileges, and responsibilities that are attached to the relationship. Then again in uh, section 2 clause D, there is a definition of the expression child in the need of care and protection has also been defined, and it is clear through this that there is somebody who does not have a parent, whom no one is willing to take care of. So even though the Hindu Adoptions Maintenance Act gives this restriction, there is now a possibility to reconcile both the acts. And that is what has been para number 20 is important for your purpose. brought in talking about the welfare of a child and the rights of the child and why it is so important that children need protection. Not when you have signed a convention like that, as India has done so, it has a duty to ensure that it is obligated to ensure that those terms of the conventions are fulfilled into its own legislation. So in para 20 becomes very important because para 20 is basically on the ground on the basis of which the court finds that there is no provision that says, I mean, that there is nothing under the JJ Act that prohibits further adoption of this child because you are not using the Adoption Maintenance Act for adoption. You are coming under the JJ Act to adopt this second daughter, which is not allowed under the Hindu Adoptions Act. Now, the adoption, the condition under the JJ Act is that it is intended to facilitate rehabilitation, like I said, of orphaned, abandoned, or surrendered children. And this condition must apply to all persons, irrespective of religious affiliation, who seek to adopt children of that description. So, children have been described as surrendered, abandoned, or orphaned, and the people who are entitled are persons irrespective of religious affiliation. And the object of rehabilitation under the Juvenile Justice Act is for providing social integration, reintegration to these children that we are talking about, and it is a matter of what the court says is high legislative policy. And it is in giving effect to this policy that the legislature has made it a point that adoption of such a child must proceed irrespective of the marital status of a person taking in adoption and irrespective of the number of living biological children of the parents seeking adoption. So when the child which is sought to be adopted, or rather falls within subsection 2, that is a child that is in need of care, or a child where you want to adopt in spite of other daughters coming into that, other children of the same sex being alive living at the time of this particular adoption, the JJ Act, the provisions of the JJ Act must prevail. So in such a case, the restriction that is imposed on adopting a child of the same sex by a Hindu, that is there in clauses 1 and 2 of section 11 of the Hama Act, it must give way to the salutary provisions made by the Juvenile Justice Act. That is what the court has said in this case. So where, however, it says, however, the child is not of a description falling under the purview of Chapter 4, a Hindu desirous of adopting a child continues to be under the embargo imposed by clauses 1 and 2 of Section 11 of the Act of 1956. If the two pieces of legislation, both of which are enacted by the Parliament, are harmoniously construed, there is no conflict of interpretation. So, what is, however, required is that for that clause 1 and 2 to become still application for that restriction to be imposed, the necessary requirement is that the child is not orphaned, not abandoned, or a surrendered child. That is the only thing. If, however, that child has been abandoned, has been orphaned, or surrendered, then clearly under the JJ Act, there is no, there is under the embargo that has been set up under the Hama Act of 1956 does not stand, and the child can be adopted for that purpose. So, as I said, if there is a new law, for example, that has already been brought in, like even if you're talking about which law will prevail, then in that case also it is the JJ Act which will prevail because unless and until there is a difficulty in construing the provisions in the right manner or interpreting it in the right way, then we will not have an issue of dealing with that case. So, in para number 34, as they go to the decision, the petitioners are Hindu, they already have a biological daughter, guardianship under the provisions of the Guardian and Wards Act of a minor child of the same sex, the child of whom they assume guardianship fits the description of a child in need of care and protection under Section 2, Clause D, Subclause 5 of the Juvenile Justice Act, as well as that of a surrendered child under Subsection 2 of Section 41 of the Juvenile Justice Act. The petitioners were eligible to adopt the child under the Juvenile Justice Act 2000, and the order of guardianship does not destroy that entitlement. The child was a surrendered child and was legally free for adoption. The substance and effect of the procedures that are prescribed under the JJ Act have been complied with. Both the children, that is the natural born child and the child that they are now seeking for the legal adoption, whom they have taken under the Guardian and Wards Act, they are both pursuing their education in kindergarten class of a nursery school, and the report has also been placed. There is abundant material before the court to conclude that it is manifestly in the interest and welfare of the child that the petition for adoption should be allowed. So petition is allowed, accordingly disposed of. Now, in this case, therefore, what you see is there is a way of reconciling this particular provision. The embargo is still there if the child is not of the description as is given under the JJ Act. But clearly in this case, the child has been surrendered by the parents. They had made a declaration which was done through counseling of the welfare board, and they were well aware of the stand that they were taking. The claim for the child within 2 months, if they decided to change their mind, that also they did not follow through, and it has already been 4 years since the adoptive parents have been granted guardianship over the child. So keeping all of these in mind, the court came to the necessary conclusion that there is no conflict, and since the child is abandoned, therefore that is the reason why the embargo that is placed, or the restriction that is there under clauses 1 and 2, clause 2 of the Hindu Succession Amendment, Adoptions and Amendment Act, was held to be not applicable, and therefore the legal adoption of the child was accepted by the court and was given in adoption. Now, another case which was decided way before the 2010 personal amendment was, it is the case that you have in your case material again, by the name of Brajender Singh versus State of Madhya Pradesh. Now, Brajender Singh versus State of Madhya Pradesh is the 2008 judgment of the Supreme Court, and we are looking at the status of a married woman who has adopted a child. Basically, a disabled married woman, you can say, and there is no dissolution of the marriage by either parties at any point of time, but she had adopted a child by the name of Brajender Singh. Now, in this case, we know that under the Hindu Adoption Maintenance Act, unmarried women, or for that matter after 2010, even a married woman with the consent of the husband, widow, as well as a divorcee, they all have the right to adopt. And this right to adopt is regulated under Section 8. A married woman also has that capacity with the consent of the husband now after the 2010 amendment. And if however this is a case that was decided before 2010, so the law that still stood was that married women cannot adopt even with consent of the husband. It was only when the husband has been declared of unsound mind by a competent court of jurisdiction, or the handicapped woman, and this handicapped married woman was left by her husband. Now, there is a very interesting thing under the Hindu law that a virgin woman is must be married. So even in Bajendra Singh's case, although she's a handicapped woman, she was given in marriage by her family because obviously because she is definitely a woman who is of a virgin girl. Now, it was long time ago. It was sometime in 1948 that her name is Mishri Bai, and she was crippled. So she had no legs, and she was given in marriage to a person by the name of Padam Singh. Now, the marriage appears to have been solemnized because under the village custom. Now, in the village, in that custom, this is Madhya Pradesh, the custom was that it was imperative for a virgin girl to get married. So, on evidence, what we see, however, is that after the marriage was solemnized, soon after, we don't know how long it was, but it says soon after, so we are presuming that it was maybe within one or 2 months of the marriage that the husband decides to leave the wife. So after that, after the marriage, soon after the husband left the wife, and then this Mishra Bai, who is a handicapped lady, comes back to her own parents, and she comes and lives in her parents' home. Now her parents, knowing how her situation, and then seeing her plight, they gave her a land of some acres out of the agricultural holdings that they own for her own maintenance. Now, in 1970, so in 1948, she was married. She is left by her husband. And then in 1970, that is 22 years later, she adopts a male child. Now, and this male child is the present petitioner right now, who is Brajender Singh. Now, the husband, that is Padam Singh, he had died in the year 1974. So the SDO had served a notice regarding the kind of the agricultural holdings, and she wanted to make a declaration to mutate her share of the property that she had in the name of her adopted son. So by this, in 1981, however, the SDO decided not to believe the adoption of this because the adoptive father's name was not recorded in the educational institution, in the class 10 certificate, etc. of this adopted son. So in 1982, Mishra Bai decides to approach the court seeking a declaration that Bajendra Singh is her adopted son. And then in 1989, she executed a will bequeathing all her properties in favor of this adopted son, Bajendra Singh. Shortly after the execution of this will, she breathed her last in the same year, and she died. And then the trial court, by their order and judgment of 1993, ruled in favor of Mishra Bai. Now this is being challenged by the state. One thing is because whenever any person dies and there is no heir to that property, there is a doctrine that is called the doctrine of escheat. And through that doctrine, what will happen is if there is no known heir traceable, then the government basically takes the entire property. So now the state has come in appeal because the state is contending that Brajendra Singh is not the adopted son, and therefore the property has no owner, so we are basically the owners. And then after that is how the state has now come in appeal. And although the judgment, the High Court allowed this appeal of the state, and it held that in view of Section 8, Clause C of the Hindu Adoption and Maintenance Act, as far as a female Hindu is concerned, only those falling within the enumerated categories can adopt a son. And in 8C, the only ones that are mentioned are whom, unmarried, divorcee, and then a widow, or a married woman with the consent of the husband. So this is how the High Court has said, and the High Court in para number 4 of your case material says There was a great deal of difference between a female Hindu who is divorced and who is leading life like a divorced woman. So very interestingly, High Court came to the conclusion that you cannot say that you are a divorced woman when there has been no dissolution of marriage at any point of time. And as you can see in the facts, the husband died before her. At no point was it found that there was any divorce proceedings that took place. Now, however, the will has been made in favor of this adopted son. Practically speaking, if there was a divorce, underage she would have been allowed to adopt, and there would have been no question of having to determine what will be the status of this adopted son. However, as per the facts of the case, the adopted son cannot be considered as somebody who is entitled to a share given through the will, because the status of a divorced woman and a woman living a life like that of divorce is completely different. That is what the court has said. So the lower court and the high court, the basic legal issue that we had to find out in this case was the capacity of the Hindu married woman as far as adoption is concerned during the subsistence of marriage. The second legal issue is, can a Hindu married woman adopt a child in her name with the consent of her husband? Now this we have already seen and known that this is a 2008 judgment, so remember that by this time the personal amendment 2010 was not yet there. So the law still was that a married woman cannot adopt a child without, even with the consent of the husband. Now the Supreme Court looks at section 6 talking about the capacity of a person who wants to adopt, and section 8, it talks about section 8, which has a very important and far-reaching change. Now it is permissible for a Hindu, we see that it is permissible for a Hindu female who is of sound mind and who is of majority age of 18 years is allowed to take a son or daughter in adoption, that we have seen, and provided that at that time she is not married or is a widow or is a divorcee, and or after marriage her husband has finally renounced the world, ceased to be a Hindu, or has been declared unsound mind. So in these circumstances, any adoption that is made by a Hindu female is considered as valid. It is this requisite capacity under section 8 that is being questioned right now. So our basic thing is Mishra Bai able to adopt, because there has been no dissolution of marriage, but she has lived her life like a divorced woman. So is living a life like a divorced woman capacity enough to adopt a child, to take a child in adoption? That is the basic question. So a Hindu wife provision in section 8C clearly mandates that a married woman cannot adopt at all during the subsistence of the marriage, except when the husband has finally, we said, conversion or ceased to be a Hindu, declared incompetent. Now, if the husband is not under any such disqualification, the wife cannot even adopt with the consent of the husband before 2010 personal amendment, because the section expressly provides for cases in which she can adopt a son or daughter to herself during the lifetime of the husband. Now, in this case, it is relevant to note that in the case of a male Hindu, the consent of the wife is necessary unless those other contingency exists. So section 8 is almost identical. The consent of the husband, however, is not provided for. So in respect to this, you have the decision here which states that the the appeal is very simple. However, it projects some very emotional and sensitive aspects of human life also, and there was no declaration sought sought for by Mishra Bai, either to the effect that she was not married, or that the marriage was a sham marriage, or that there was any divorce. So it could not be called a sham marriage also, because it was not sort, so it did not come under the definition of a sham marriage also. Therefore, she was not somebody who we can say did not enter into a valid marriage. And for her to adopt, she needed to first dissolve her marriage, then only she could adopt under the Act. So since such declarations are not made, from the law that is there in the Hindu Adoptions Maintenance Act, it is clear that only a female Hindu who is married and whose marriage has been dissolved, that is, a divorcee only has the capacity to adopt. In the instant case, there is no dissolution of marriage. All the evidence that points out is that the husband and wife were staying separately for a very long period, and Mishrabai was living like a divorced woman. Court says that there is a conceptual and a contextual difference between a divorced woman and the one who is leading a life like a divorced woman. Both cannot be equated. Therefore, in law, Mishrabai was not entitled to the declaration that she sought, declaring Rajendra Singh as her adopted son, and the appeal was dismissed. Unfortunate time, but if it had happened after 2010, probably we could have said that we couldn't. Then also we couldn't call her. We can't. We have to take the help of the husband. The husband has already died, and even after 2010, also if this case came up to the court, that consent of the husband would have been a requirement. And since the husband is no longer alive, again she would still not have been allowed to allowed to be taken, allowed to have that recourse. But at the end of the last paragraph of the case, the court sought the state to look into the question of giving possession to Brajendra Singh for at least 6 months so that he can deal with whether he can have recourses to other laws. But as far as they said that we are not laying down any order, passing any order, we have left the discretion to the state on how they should be done, because Bajendar, after his adoption, has done his duty towards Mishrabai, and as an adopted son, he has fulfilled his duty and obligation of taking care of this of this mother, of his adopted mother, who was in fact crippled as well. So these are your two cases on adoption. Go through it as you read your case material. You will find both of them there. There shouldn't be any difficulty in understanding them. We will just. I expect you to go through them, and then one is on the status of this kind of whether divorce and living a life like a divorced woman are not one and the same. Yes, Brinda.
Ma'am, this 2010 amendment, can this be applied retrospectively?
No, it cannot be applied retrospectively.
Okay.
It will be prospective only. Yeah. Because there is nothing in the rest of the amendment in the Gazette also where there is a clause that says that it will repeal those others, and then because any amendment for that purpose, any new enactment, remember it is always prospective. There is hardly any retrospective application. Now in the Hindu Marriage Act, where you have seen that before and after. Now there is a clearly written words that it is supposed to be read prospectively as well. So even if the marriage was before and even if the marriage was after, that section will apply. If there is no word like that, it means that it is from the date of the enactment, that is, it has to be read prospectively. Right. And this amendment also, therefore, it is not retrospective. The personal amendment, it is prospective. Okay. So I take your attendances. Kajal, 428. Present, ma'am. Kumar Ashish.
Yes, ma'am.
Shivaram.
Yes, ma'am.
Shivaram Raje.
Present, ma'am.
Nandan Kumar. Prakash Raju.
Present, ma'am.
Atul Goswami.
Yes, ma'am. Present.
Riyal Gupta.
Present, ma'am.
Riji Gupta.
Present, ma'am.
Tushar Gupta.
Present, ma'am. Prashant.
Anmol. Anmol.
Present, ma'am.